Hello, everybody. Adam Parks here with another episode of Receivables Roundtable. Today, I am here with Bryan Schneider, who is a partner with Manit, coming to us from the legal side now, but previously working and living on the regulator side of the equation for quite some time. I had the opportunity to meet him at the Lend 360 conference a couple of months ago and just learned so much for a short conversation over lunch that I wanted to have him on and see if he could chat with us a little bit about his experience coming over to the private side after being a regulator. How you doing today, Bryan?
Just fine, Adam. Thanks for having me.
Absolutely. We appreciate you coming on. For anybody in the audience that's not familiar with you, could you tell everybody a little bit about yourself and how you got to the seat that you're in today?
Well, sure. The tortured tale of my law practice. I've been practicing law for decades now. I began my career in the private practice of law, but spent many, many years as in-house counsel for a large pharmacy chain that operates on a national basis, and really enjoyed in-house practice. It's a great privilege to be able to represent one client and really dig into their business, understand how it works. I try to replicate that as much as I can in my current role, because I think you give better legal advice the more you know about the business, and quite frankly, how various aspects of the business are affecting other aspects of the business. So I really enjoyed my time in-house. And then along came something of a surprise here in the state of Illinois. We elected a Republican governor in 2014, which was something that I'm not sure a lot of people ever thought would happen again. But it did, and it opened up for me an opportunity to take the helm at the Illinois Department of Financial and Professional Regulation. And it's a somewhat sprawling department in the sense that it licenses literally tens of thousands of individuals in all sorts of professions: doctors, pharmacists, debt collectors. It goes on and on, and in ways that touch those professionals. It's their livelihood when you're talking about their license, and of course, they touch so many consumers that I would get an earful no matter what dinner party I was at, because someone either liked or didn't like what I was doing to them, or for a consumer that they had impacted. But the vast, probably big swath of our work at that department was financial services regulation. Illinois has the most state chartered banks in the country, almost the most number of state chartered credit unions. Of course, we licensed thousands of fintechs and non-depository companies. And I really got a chance to work with industry, work with consumer groups to try to figure out how are we going to make state regulation, which is often criticized as being a patchwork quilt of requirements. How are we going to make that more impactful for consumers, more readily navigable by companies that we regulated? And to do that, as a result, I needed to work closely with my fellow state regulators. So I was quite involved with the Conference of State Bank Supervisors, the National Association of State Credit Union Supervisors, and other related groups to, try to harmonize where possible the substantive requirements of state law, but perhaps equally importantly is at least make sure our process is knit together, so that if you're confronting basically the same issue in multiple states, can that be coordinated in an effective way? Mm-hmm. I was also very concerned, quite candidly, about innovation. I thought that, as a regulator, obviously protecting consumers is the most important thing you can do at base. That's why you're there. But regulation that really wasn't tailored to the marketplace as we were then finding it, I thought really ran the risk of becoming over-regulation and keeping new products and services away from consumers. There's no, you basically kill ideas, you kill baby ideas in their cribs if you are not attentive to innovation. So always spent a lot of effort on trying to do things that now seem second nature, but quite frankly weren't 6-7 years ago. Things like regulator office hours, making sure people knew that they had questions, no matter how simple or complex they were, that they could come to our office at a certain time and present them, back when we used to come to offices and not do everything by electronic media. Tried to work very hard in Illinois on sort of regulatory sandbox ideas. How can we give innovators in the financial services area a space where they can, closely supervised, I might add, offer new things in ways that just didn't fit, round square pegs in round holes sort of thing. Don't stop trying to shove new ideas into old regulatory boxes, but create a new space for that. At the time, we came up a little bit short in the legislature in Illinois, despite a valiant effort. But I note that many states, I don't want to say followed our lead, but I think saw what we were doing in a place like Illinois, and we took notes from other states, and they took notes from us. So it was glad to do it. Eventually, that tour of duty ended, and I moved over to the federal side, and I became the Associate Director of Supervision, Enforcement, and Fair Lending for the Consumer Financial Protection Bureau. It's a very important agency. It was itself, going through a transition in leadership as one president's term ended and another president's term begun. And it's a very new agency by federal government standards that, celebrated its first decade of existence while I was still there, compared to other federal agencies that, of course, have existed for many, many decades, and in some cases, a couple centuries. So that was a great, process to try to, balance. The CFPB is said to have 4 tools. The CFPB supervises entities. It takes enforcement actions. It regulates. It writes regulations. It writes commentaries to regulations, and then it educates consumers how to, take charge of their financial life as much as they can. And my division had responsibility for 2 of those 4 tools. So spent a lot of time trying to make sure we balanced those tools within the other 2 that were at the Bureau's disposal. And then also making sure that balance between supervision and enforcement was proper. At different times in the agency's history, I think early on and perhaps now, the agency leans more heavily on the enforcement tool. I tried to make sure that we were very careful to not over or underutilize either of the 2 important tools that I was trusted with. And that's a balance. Consumer groups and industry groups don't see the same way on that. So trying to keep that balance, trying to make sure that we have the staff available, to do what we needed to do, and navigating all of this through the COVID pandemic, when we, like everyone else, one day had to shift to doing everything remotely, when all of our work prior to that had really been, any company that's ever been through a financial services examination knows that the typical pattern is a group of examiners descend on your office. Suddenly that had to be done in a completely different way. When my time there came to an end, I was pleased and honored to join Phelps Phillips, well-renowned law firm with a national reach as a partner in their Chicago office. I'm part of the Consumer Financial Services group, but we do some work, particularly with respect to small business lending, related commercial lending, and that space. There's some overlap there, of course.
Excellent. So, now that you're over with the law firm, tell us a little bit about the firm itself and what you guys really are focused on over there.
Well, Manat we like to consider ourselves an integrated professional services firm. We are, by no doubt, a law firm. We have skilled lawyers across the country, several offices in California, Chicago, New York, Boston, Washington, D.C. Albany, New York, New York City. So we have very broad reach with respect to our legal practice, some of the best lawyers in all of our practice areas that you'll ever want to deal with. But we also have within our firm a number of non-attorney professionals in all of our practice areas. Healthcare and financial services are two of our more prominent professional services areas. So we have a number of, like I say, non-attorney consultants. And I view their involvement. I have nothing against lawyers. I've made my living as a lawyer for a number of years. But having the perspective in your own firm and the ability to tap into someone who doesn't look at things exclusively through a legal lens, but through an operational lens, who has experience actually implementing great ideas that lawyers have, is exceedingly valuable, and I think a great value driver for our service propositions that we make to clients.
Fair enough. Now, that transition from being a lawyer to a regulator to obviously different type of regulation, both state and federal, and then coming back onto the private side, do you feel that gives you a unique perspective on navigating the financial services water, so to speak?
I certainly like to think so. There's certainly some contacts that one develops if you spend time in the regulatory pool as a regulator, and certain relationships that you have that you can, call on to help clients better understand what their obligations are and how to navigate what can admittedly be a seemingly simple but oftentimes in practice complex environment. I think it also helps to know, well, what do they think is important? What types of arguments will move them to consider your position a little bit more seriously, a little bit more favorably. What types of arguments have they heard? What types of the dog ate my homework arguments have they heard so often that you can make them, but they're just not likely, the juice is not likely to be worth the squeeze.
Fair enough. What an interesting way to look at that. But beyond the relationships, and kind of that perspective, have you found that your understanding has enabled you to kind of better advise a client on kind of what comes next? Because you've been through those experiences now. You've got an understanding of what the process and procedure looks like. Are you better prepared to assist a client in setting their expectations?
Oh, for sure. I like to think so. Better how quickly, how fervently something is likely, to be pursued. Where things are relating into different priorities. So you can help people understand, look, this doesn't seem that big of a deal. Seems like you've got plenty of time, but we really need to jump on this. When you do a meet and confer and it, is scheduled within, a handful of days from the time you first receive the notice, take it seriously. They're trying, at the end of the day, I have found regulators, they're heavily evaluated themselves by government oversight groups, by units of government within the government that are kind of checking up on them and writing reports. How quickly do they process things, et cetera, et cetera. And they take that, as seriously as any of us do take, sort of being evaluated. So, they're often reasonable when it comes to things like deadlines, but, helping folks understand that, they just are not an utterly unaccountable group, sometimes, can help drive decision making and kind of just drive mapping something out. It can also help you to understand, look, this is something where, how are we going to solve this problem? How might we remediate this? Here are some ways that, depending on what your ultimate business goals are, but here are some options for ways to remediate things that have worked in the past. Are these options good for you? They might not be immediately apparent. It might seem like the only option you have is, fight or flight. And in reality, it's a little bit more nuanced than that. So early identification of those other approaches, enhances kind of the optionality that the client has, and gives them the ability to make, hopefully a little bit more nuanced and a little more nuanced decision about how they want to handle something, rather than just, well, we either have to give up or, we have to fight to the Supreme Court. It allows them to make the business and the legal meld together a little bit better.
Fair enough. And, I think the industry perspective on the CFPB has been that they've been a somewhat unaccountable organization. And I've heard it said that, even calling the director before Congress, he's required to come in, but not necessarily required to answer questions. And so I think the visibility of the organization itself, and there's a delicate political balance to the CFPB as well, right? Because I think both sides of the equation are ultimately trying to help the consumer. They just have a different perspective on what helping the consumer ultimately means. Did you find, that, being in a leadership role within an organization like that, are you still accountable, maybe not necessarily to Congress, but to other government reporting entities? Like, what's that accountability truly like from within the Bureau?
Well, certainly, the Bureau has accountability in the sense internally that there's a single director, and that raises some concern. There's some thought that, look, if there were a board, that would allow different sort of coalitions to develop as the agency considers important issues, and it wouldn't be so single-minded. I will tell you, working within the Bureau, having a single director, it does allow you to orient your work towards that director's goals, because the goals are arrived at by the director after careful consultation with the staff. But once they're there, and you can orient to them. The SALA law decision perhaps made the director even more directly accountable in the sense that he or she responds directly to the President of the United States and can be removed by the President of the United States at any time for any reason or no reason at all. So I think in that level of accountability, there's pretty good alignment between the CFPB and the executive branch. With respect to Congress, there's some important policy decisions, I think, that remain. You're right. The director gets called up before Congress and can get called up more frequently. And if there's a change in the next Congress, I think I would expect the director to be called up there fairly often. He might, start blocking time on his calendar, I'm sure, to testify before Congress. And that's important, that oversight function, Congress calling attention to what an agency is doing and calling it out or calling it in, depending on your perspective, is important. But it is true, the agency is not accountable to Congress with respect to its annual budget. The Bureau has the ability to obtain funding directly from the Federal Reserve System, and they do not have to go to Congress each year and explain themselves and justify their budget and ask that the Congress approve it. And that does deprive Congress of some important oversight and some important control on their activities. And that's by design. Of course, the folks that wrote the Dodd-Frank Act designed it that way. Whether or not that's advisable, I guess depends on your perspective.
Fair enough. And let me that all incredibly great information, Bryan, and I can't thank you enough for coming on today. But like one more question for you. If there was one myth, about the Bureau and kind of that regulatory environment around consumer financial services that we could try and dispel for industry today, any thoughts on what that myth might be or how we could dispel that myth?
Myth.
It's a broad question, right? I think you understand the perspective of both industry and regulator.
I do understand. I think maybe I'll come at this. There's a couple or different aspects. Different aspects of the same myth. One myth might be that the enforcement arm at the Bureau is just completely unthinking and almost, an automaton for, bringing enforcement actions on any basis whatsoever. I think that, knowing how the process works, there's a lot of careful thought given to, by time you see an enforcement action, you still may disagree with the result. You absolutely, substantively may think they pressed too far. A lot of efforts right now to sort of press as far as that statute could go, and very fair arguments to say that needs to stop. You should start looking. You should start staying more in your lane. But the thought that the Bureau gets there through sort of an unthinking, thumb on the scale for enforcement all the time, I think that's a myth. It's a very careful, deliberative process. Entities, particularly supervised entities, oftentimes, will have an ability to, interlocute with the Bureau that they should take, very seriously. And I have found in my experience, the more seriously you take, for example, getting a PAR letter in an exam, then the more likely it is you are able to resolve that on terms that seem more reasonable to all parties concerned, the Bureau and the institution.
Well, fair enough. And Bryan, I can't thank you enough for coming on and chatting with me today. This was all great information. For those of you that are watching, if you have additional questions that you'd like to see me ask Bryan, you can leave those in the comments below. Hopefully I can get Bryan to come back on again in the future and continue helping me create great content for a great industry. In the short term, Bryan, I will have your information below so that anybody who's got additional questions can reach out to you directly as well. But I really appreciate you coming on and taking the time to talk with me today. I think it's important that we continue to look at the regulatory environment as a positive thing and how we can start to bring those worlds together for really to achieve the same goals, right? I think industry is looking to protect the consumers. I think regulators are as well. And the more that we can bring our perspectives together to resolve those issues and to continue protecting consumers would be incredibly important.
I agree. It can be a partnership. It is not a purely equal partnership. The regulator, is in charge of some things, but I think the more industry and regulators work together with consumers, the better the result is for everybody.
I agree wholeheartedly, Bryan. Thank you again for coming on today, and I look forward to seeing you again soon.
Thank you.